Welcome to immigrationquestion.com, your trusted guide in the world of U.S. immigration. We provide clear immigration news and insights and connect you with experienced attorneys who can answer your questions and guide you through the process. From visas to green cards, asylum to citizenship, we help you find the right legal expertise so you can move forward with confidence. Immigrationquestion.com, real news, real answers, real quick. Stay tuned, we go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, your trusted source for immigration news, expert legal insights, and real-time conversations with licensed immigration attorneys. I'm Max Castro, and I'll be your host for today's crucial session, how to prepare for a potential ICE encounter and protect your family unity in the United States. In recent months, concerns over ICE operations have grown across immigrant communities nationwide. Reports of unexpected encounters, increased detentions, and even violent incidents have raised urgent questions about safety, rights, and family preparedness. That's why we're here today to provide you with clear, practical information on how to respond safely during an ICE encounter, protect your rights, and take proactive steps to preserve your family's unity and stability. We are honored to be joined by attorney Andrew James Newcomb, a dedicated immigration attorney with over a decade of experience in asylum, removal defense, and family-based immigration. Licensed to represent clients at every appellate level, he is deeply committed to help families reunite and stay together. Attorney Newcomb, we are delighted to have you join us today. Welcome.
Thank you very much, Max, for the invitation. I'm delighted to be here with you today as well.
We appreciate that, attorney. Before we begin, a brief but essential reminder, immigrationquestion.com is a platform that connects users with licensed immigration attorneys. We are not a law firm and we are not affiliated with AILA or USCIS. All legal services are provided independently by attorneys in our network. Let's get started. Attorney Newcomb, to begin, can you walk us through what individuals should know about their rights during an ICE encounter, whether at home, in a vehicle, or in a public place? What should they say or avoid saying to stay safe and protected?
Thank you for that question, Max. And before I jump into the specifics, I'd like to address just very briefly a little bit of confusion about the recent Supreme Court decision regarding racial profiling that stemmed out of the case that arose because of the Los Angeles kind of actions on behalf of ICE, and what that means and what that doesn't mean. So a lot of people think that the Supreme Court said the Fourth Amendment doesn't exist and they can just stop anybody because of their race and talk to them. And while the practical reality might be in the short term, ICE is no longer constrained, right, by this judicial case, what the Supreme Court actually said was the judge overstepped his authority in restricting an entire agency from doing certain kinds of behaviors until it's gone through and it's been fully litigated. So they're not saying the Fourth Amendment doesn't exist. You don't have the right to remain silent. You don't have the right against unreasonable searches and seizures on your person. What they are saying is that we're not going to allow a federal judge to stop the executive. And we can get into whether or not that's hypocritical based on some of the actions that they defended when it was a federal judge blocking Biden, right? And how that's kind of changed. But what it doesn't mean is that ICE agents have the right to just run roughshod over you and your constitutional rights. And it's important to mention that because if people start to feel like they don't have any right in a situation to say no or to refuse to answer a question, it gives all of the power to ICE. And I think some of that confusion is by design. So I want to be very clear about that. The Fourth Amendment still exists. They still have to have probable cause to stop and detain and search somebody. And so generally, if you're in that situation, if you're walking out on the street or if you're in a public place, like for example, the lobby of a hotel or a public parking lot, ICE can approach you and they can ask you questions if they have reasonable suspicion that you might have committed an immigration violation. In that situation, what you shouldn't do is start to explain your situation to the ICE officer. To say, oh, I applied for a U visa 2 years ago. I'm still waiting on my, deferred action and bona fide determination. Or, oh, officer, I've been here for 30 years. I've got 3 children who are U.S. citizens. One of them's in the Marines. Any kinds of explanations like that are just giving ICE officers that pretext that they need to make that detention. Because the minute you start explaining your situation, they can infer from that, oh, this person doesn't have their green card yet, and therefore I can make a detention. So any argument as far as I have deferred action for my U visa, or I have an adjustment of status pending, and my work permit is related to that, it's better actually to wait until after ICE has made their own determination on whether or not they're going to do a detention, and then bring up those arguments in front of an immigration judge. Even though it can be scary, there's an instinct to want to try to explain your situation immediately, show your work permit. But as we've seen, people with work permits from asylum cases are still getting detained because there's a new law that states that essentially if your last entry was without a visa or without permission, you're ineligible for bond, right? So we want to get those cases dismissed. And if ICE is detaining people and arresting them without probable cause, that can be an excellent tool to get your case dismissed. Generally, I would say the first thing you should say is, am I detained right now, to an officer of ICE? Because that forces the burden on them to articulate why it is that they felt they had a reasonable suspicion to discuss with you. And if they know that they didn't, they might say no, at which point you should walk away. Don't try to resist or run away or anything like that, because that similarly is going to give ICE officers that kind of authority. If you're driving in a vehicle, the driver of that vehicle must hand over a driver's license if they're detained by ICE officers. The passenger and the people in the back of the car don't have to hand over any documents. They don't have to say anything, and that would be my recommendation, that they not hand over documents or say anything, which means as a family, if you're planning a trip, the person driving the car should be the one that has lawful status, and he or she should be the only person discussing that with an ICE officer. If you're in a building or a place of work or your own residence, for example, you should demand to see a judicial warrant signed in order to allow an ICE officer to come in, which means talk to your employer, talk to people that are owners of buildings at sporting events that you might want to attend, and assure from them that they would require a signed judicial warrant and they wouldn't just allow ICE officers to come in. That's a very important conversation to have with your employer or to have with someone in that private setting.
Thank you for ensuring clarity for our audience, Mr. Attorney Newcomb. What many immigrants are understandably afraid of are unexpected visits or detentions. What practical steps can families take right now to minimize their risk of detention if ICE ever shows up?
So there are two things that someone can do. So there's certain people that are in a greater danger of being looked for by ICE, right? And those people essentially are folks that there's three categories, I would say. People that came in with some kind of parole during the Biden years, whether that was a family reunification parole or it was a parole so that you could start to take on your asylum case. Those people, the government has that information and they consider that the Biden administration overstepped by allowing those people in. So that's one area of concern. The other area of concern is people that already have a deportation order here in the United States. And the third one is people that have a criminal history. So let's address them one at a time. If you're in that first group of people, let's say you had a family reunification parole and that parole has expired, you may still be entitled to apply for an asylum benefit. So for example, if you come from Venezuela or Nicaragua and you're here on the family parole program, the heads of state of those countries have said, we're not welcoming those people back into our country. Those people have betrayed us, et cetera, whatever language they use. That statement from the head of state in and of itself creates a very viable asylum opportunity. So if people aren't ready to leave yet, they should file their asylum affirmatively with USCIS, get the receipt, and apply for their work benefit 5 months later. That would be my advice for people in that first category. If they don't feel like they have an asylum, maybe they're from a different country, Honduras or Guatemala, and they honestly don't have a fear of returning to their home country, then they can consider options about marriage-based petitions. There's usually options that can be explored. Obviously, U visas, any kind of immigration benefit for folks that entered in that first category is something that they should definitely pursue. Category number two, and this is a difficult one. If you have an order of removal, most of the time there doesn't exist a really good basis to try to reopen and terminate a prior order of removal. So we have to show either that the attorney was disbarred and that you were the victim of fraud. Maybe they promised you something and they didn't show up the day of that hearing, or they gave you bad legal advice and they told you not to show up. Or they just didn't send anything into the court and they just disappeared. So those kinds of things were very common, especially in the early 2000s. So if that is a situation with you and you've looked up the former attorney for your parents, for example, and you find out that they've been subject to discipline from their state bar or that they've been disbarred, then that can be a very powerful basis to reopen and terminate those proceedings and then pursue other collateral relief. Similarly, if someone's experiencing new threats of violence or they have a new eligibility for deportation relief, you can file a motion to reopen with the Board of Immigration Appeals. So those are very technical questions that should be analyzed with an immigration attorney to see if it's worthwhile. Because if there's not really a likelihood of being able to move forward and succeed on the merits, I would recommend basically not moving the water right now. But if there is a good shot to move forward, if that attorney has done negative things, or if there's a new eligibility, then I would move forward there. The third category, very important, and I really want to emphasize this and highlight this because it's really one of the most important preventative measures that someone can take right now. If you have a criminal record, step one is reach out to an attorney and find out if those crimes are crimes that are called involving moral turpitude. It's a CIMT, crime involving moral turpitude, and those can make you inadmissible or even subject to mandatory detention here in the United States. So even if you have a green card and after being granted your green card, you've been convicted of CIMTs, it's not recommendable that you should travel because you may get placed in detention and removal proceedings. But even if you're in the process of applying for your green card, let's say through U visa, and you have a certain criminal history, it's important to, and it's especially in the case for U visa, which is a discretionary form of relief, right? That they look at all the good factors and they weigh them against all the bad factors. So the way that reopening and vacating a prior conviction works, it's different from an expungement. A lot of attorneys will try to sell you on the idea of an expungement, and that can be great for your credit score, for job applications, that kind of thing. Expungements generally don't have any effect, positive or negative, on your immigration application. What you have to do is you have to file a motion to reopen and vacate the prior conviction based on what? Based on ineffective assistance of counsel from my previous attorney, who in many cases, these public defenders, they don't advise their clients of the immigration consequences of a particular plea, of pleading no contest or guilty to a certain charge. And it's helpful for them because then they have a deal made and they can move on to their other clients. And a lot of these public defenders are overburdened. So from the DA's perspective, if I, let's say, was convicted of possession of a controlled substance, I paid my debt to society, I did my week, my 10 days in jail, and I did my I did my probation, I paid my fines, I attended all my classes. The DAs aren't trying to create a double penalty for people that are in the process of fixing their immigration status, right? They don't want to punish American citizens differently than green card holders. So what we do is we say, hey, there's an additional collateral consequence to me having taken this plea, and it means that my dad is in detention right now. They're not giving him his medicine, and he's suffering tremendously. When there's a conviction more than 5 or 10 years ago, and someone's kept their record clean since then, in most cases, the DAs are very willing to do this. Now, I have to be fully transparent. I don't actually do this process. This is for a criminal attorney, but this is where we see the intersection of immigration law and criminal law. And it's very important to research with an immigration lawyer, hey, do I need to reopen and vacate these convictions? And then get a referral from that immigration lawyer to a criminal attorney. We can work together on the case and get those convictions reopened and vacated. It's super important to do if anyone that has any type of criminal history.
Thank you so much, attorney. And for individuals who have a criminal record, even just a minor one, the risk of detention can be higher. What immediate legal or administrative actions such individuals should consider taking to strengthen their position and protect themselves further?
I think it's generally a good idea to reopen and vacate any conviction that you have, regardless of whether or not it's for a crime involving moral turpitude. If the conviction just happened within the last 3 years, the DAs are probably not going to be open to that. But if it's a conviction 5 years or more, and you can show, you really just have to negotiate with the district attorneys, explain you have a family here, which is why I would recommend hiring a local attorney that generally works within that county, because they're going to have those relationships with those district attorneys where they can get those cases reopened and vacated. And that eliminates any argument the government might have. So they can't charge you with being inadmissible for this conviction if that conviction doesn't exist anymore. And so recall that you need to do a reopen and vacating. You don't like a simple expungement is not going to be sufficient in this context.
Thank you so much, attorney. And we know that detention can disrupt more than just immigration status. It can also threaten homes, finances, and family assets, right? What advice do you have on how to safeguard property, bank accounts, and essential documents in case a family member is detained?
Yes, very good question. And so there are 2 different tools that attorneys recommend given this climate of increased detentions. So a lot of people that are undocumented, rather than invest in like a mutual fund or the stock market, a lot of people have invested in property. And so it's important to think about, what do I do with my bank accounts, with my different property holdings? The first tool is called power of attorney. And you can name someone over 18, either a child or a sibling or a very close trusted friend, to act in your stead and be given power of attorney, which means that they can make repairs, collect rents, take out a second mortgage, sell. You can specify in that document exactly what powers you want them to have. So if you find yourself deported and you're not able, or in immigration detention, and you need to raise money for your defense or whatever the situation is, that person could step in and continue to manage that property and or sell that property. So that's something that's very useful, especially when you have actual brick and mortar locations and real estate. The other one is a living trust. And a living trust is something that I would recommend for anybody, regardless of their immigration situation, because it makes very clear the division of assets in the event of a triggering event, which is typically incapacity or death. But in this situation, if someone's deported from the United States and they don't have any lawful means, they've decided to repatriate in their country, and they're not going to be back in the United States, the living trust acts in your stead. So let's say years in the future, the person passes away in their home country and they have all these assets left in the United States. So what the living trust does is it allows me to specifically say, I want this surviving family member to have this, and I want this child to have that, because it may be that, one of your kids is doing a lot better than the other, and you want to try to support that child that's not doing as well, but you don't want to give them a lump sum payment because they just turned 19. You're not confident that they're going to be able to manage the money correctly. So you want to try to have maybe their older sibling act as a trustee and give them a spendthrift amount to say, okay, here's $2,000 a month that will help you cover rent, so that I can know that, you won't be in a situation where you're facing homelessness or something like that. And also the living trust, you can have provisions in it that if any of the beneficiaries contest your distribution of assets, that they immediately are excluded from the trust. And that right there prevents that intra-family fighting. That's one big benefit of the living trust. The other is you don't have to go through probate court, because the trust is like an embodiment of you. It's alive and it carries on your assets. So you don't have to go through probate court and get into that nasty and costly litigation where you're trying to divide up assets. So power of attorney to have someone in charge of managing your affairs, and a living trust so that you have your exact asset distribution spelled out. I think those are two very important tools for in case somebody's concerned about a detention.
Thank you, Attorney. And I know that you will also agree that the value of being proactive cannot be overemphasized. So can you explain the importance of filing for immigration relief early, such as asylum, cancellation of removal, or adjustment of status, and how it can serve as a layer of protection against detention or deportation?
Yeah, absolutely. So right now, a lot of people, their reaction is, okay, maybe my son or daughter has turned 21 and I entered with a visa and I'm eligible for an adjustment of status, but I don't trust this administration. And so I'm going to stay home and I'm going to lock my door and I'm going to send my kid out for groceries, and I'm not going to apply for anything until January 2029 or later. And I understand the impulse and I understand the fear. I really do. But it's not a wise strategy, because we haven't even seen the new ICE budget hit yet. It's been approved through the congressional bill that they passed this year, but it hasn't been dispersed yet. So starting January of 26, we're going to start to see, I know it's hard to imagine, but an increase of ICE activity. And if you have a collateral relief pending with USCIS, so you have a adjustment of status, maybe you're a recipient of a prior petition, and you can apply for 245I if someone petitioned either you or your parent before April 30th, 2001, or you've been the victim of a crime and you have U visa, or you've been the victim of domestic abuse, psychological, physical, or otherwise, and you have a VAWA claim. That abuse can be from a U.S. citizen child over 21 or a spouse. So there's a lot of different options. It's important to review them with an immigration attorney and to put in that request. Now, of course, there's an added danger to it right now, in the sense that an adjustment of status that gets denied, or a family-based petition that gets denied, in many cases, they're referring those people towards immigration court. So now more than ever, it's very important to not have someone who's, a tax preparer, or someone that they call themselves a notario, someone that, that term for a lot of people in Latin American countries carries an implication that they have legal training and knowledge. And so people here that term themselves that, they kind of take advantage of the community. And in some cases, they can do, basic immigration filings, but the consequences now are so high that if one of these petitions, if a request for evidence comes in and it gets ignored, or the case gets sent to the National Visa Center and it's not followed up on, those are two situations that I've seen where they sent a notice to appear to someone and they'll have to go to court and have to defend their deportation. But let's say I'm in a situation a year and a half from now and I get detained by ICE and I have a hearing before a judge and I say, well, Your Honor, my wife could petition me, but we were too scared because of this administration, and so we didn't do it yet. That's a much worse position to be in than to say, Your Honor, I have my I-130 approval. I'm filing for my 601A waiver of unlawful presence. We're already very advanced in this process. We're eligible for this relief because now the judge is saying, okay, I have a 4 million case backlog. Obviously not that specific judge, but nationwide, there's a plus 4 million case backlog. So if they see that an applicant doesn't have a criminal record or that it's already been reopened and vacated, and they're in their line for a process of relief through another agency, because we have the Executive Office of Immigration Review and we have United States Citizenship and Immigration Services. So if this group over here is aware that this other government agency right here can finish your case, then in many cases they do dismiss, and judges still have absolute authority to dismiss those cases. So you don't want to be in a position where you're saying, Your Honor, I could have applied for this, but I just haven't. You would have to get a really friendly judge in order for the judge to still be able to entertain the idea of closing that case. So that's why now more than ever, if you have more than in any other time, if you have a legitimate claim, it's important to move forward. Now, I should say as a caveat that right now, because of this kind of fear that's pervasive in the community, a lot of immigration law firms, particularly larger size law firms, are getting desperate because they have a huge amount of overhead they need to cover. And the temptation to kind of say someone's eligible for something when they're not really, or to over exaggerate the likelihood of their success. For example, on a VAWA case, like if there's not really an extreme pattern of abuse, but they're kind of exaggerating it, be very careful with that right now, because it's a climate in which not only, so things have gotten more difficult, so a lot of big immigration law firms have become more desperate. So reach out to your local consulate of your country of origin, ask to see if they have an attorney that they recommend, someone that they trust. Reach out and look to see if an attorney's been subject to discipline, what the reviews are for a private company. Don't just trust everything that an immigration lawyer would tell you. And I would recommend getting a second opinion in this climate.
We really appreciate the discussion we're having, attorney. Thank you so much for bringing such clarity. To everyone tuning in from Facebook, YouTube, LinkedIn, and beyond, thank you for joining us for this essential discussion. Whether you're an immigrant, a family member, or a community ally, this conversation is about empowerment, awareness, and protection. If this is your first time joining us, welcome. ImmigrationQuestion.com is where individuals and families can ask their immigration questions for free and get connected directly with licensed attorneys. You can ask in any language and receive personalized legal guidance. Many of you may also qualify for a free confidential consultation. We're also proud to share that Immigration Question is now a BBB accredited business, recognizing our commitment to transparency, honesty, and serving immigrant communities with integrity. Attorney Newcomb, with the years of experience as an immigration attorney, what are your thoughts on immigrationquestion.com, who is helping immigrants and even attorneys like yourself?
I think right now the most important thing that we can do as a society is remain informed, because a lot of what you see on social media is actually misinformation. And so I appreciate that Immigration Question tries to find licensed attorneys that have a good reputation to be able to unpack topics and be able to explain them. Today, for example, I have a radio program. Today, somebody called in and said, I've heard that if you have an ITIN for 3 years, they give you your permanent residency. So that's completely false. And you just have people that have these ideas of different ways that you can move forward, or they have an overly exaggerated idea of the danger. They say, well, hey, people are being detained outside of asylum court. Why should I apply for a benefit? I'll just be arrested at my hearing. When they don't understand those are two different contexts, and there's a reason that they're looking for certain people at this asylum court that does not apply to people applying, for example, for a marriage-based benefit. So I would encourage people to reach out to resources like this to stay informed, because things are changing so quickly right now in this administration with regard to how immigration laws are being analyzed and interpreted and applied, that it's really important to get competent legal advice.
We appreciate your response, Attorney Newcomb. And before we move on into the live Q&A, where we take questions from the audience, I have one final question for you. For mixed status families where some members are U.S. citizens and others are undocumented, what are the best strategies for maintaining family unity and emergency preparedness, both legally and emotionally, if an ICE encounter ever occurs?
Right. So as I've touched on this briefly when I discussed the driver of the vehicle having to provide ID, but the other passengers in the vehicle are not required to provide ID. So if you're taking a family trip, or if you have a law enforcement officer that's knocking on your door, make sure that the person who answers the door, obviously, is the person in that mixed status family that does have lawful status. That would be step one. Number two, if it's a mixed status family, for example, grandma has a green card, mom and dad don't, and the child was born here in the United States, those parents are eligible for petition waiver and consular processing. So you don't need to have a spouse to do a waiver. You can do a waiver through your parents. So even if only one of the four grandparents has a green card, as long as they have a child over 21, you can do mom first. For example, if it's your maternal grandmother that has the green card, and once your mom has her green card, now you can start to apply for dad to get his immigration process started. So I would definitely review those options, because in mixed status families, sometimes there's an opportunity to do what's known as chain migration and fix one person's status like I just described, and then go on and fix the spouse's status. And, I think staying informed, as far as the emotional component, I mean, I can relate to that as well. I had to take Instagram off my phone just because videos of ICE detentions it's traumatic to watch, and it gives you anxiety. It makes you depressed. I would try to, to the extent that it's possible, stay off social media. Don't try to, because a lot of what this administration is trying to do is fear tactics. They have cameras when they do these like horrific beatings and detentions. They're trying to keep people scared. They want people on edge. It's part of their overall strategy to inspire people to just voluntarily self-deport. So they think that this is a great idea for them to have their agents doing these horrific things and make them super public. So I would try to steer away from that and just focus on having discussions with the family. Reach out to employers, right? If somebody is undocumented, they're working for someone, have a conversation with their employer and say, hey, if ICE shows up to the workplace, what is your contingency plan for that? Very important to have those discussions as well.
Thank you for expounding further and being brave enough to speak up, attorney. If you're just joining us, we've been having an incredibly informative conversation with attorney Andrew James Newcomb on how to prepare for a potential ICE encounter and protect your family unity in the United States. Here, we're going to go ahead and continue with our live Q&A segment. This is your chance to ask your own questions. Drop them in the chat or call us live at 516-703-3483. That's 516-703-3483, and we'll answer as many as possible. All right. So we did get a question. However, I just need to wait for the team to show it on screen. We do have a couple already coming in.
Okay, sounds good.
All right. First, we have a question from Jim Parker. He's asking, hi, I would like to ask a question. How does USCIS for a K-1 visa look upon an addendum 2 weeks after it has been submitted to correct something that I messed up on?
Thanks, Jim, for that question. So generally, when it comes to consular cases, right, like a K-1 visa or like someone doing consular processing, when you submit everything, they don't really review other information that you submit after you hit submit. So with the K-1, there is a possibility to submit an addendum, but there's a strong likelihood that the officer will not have reviewed that prior to the actual interview at the consulate. So I would just prepare original documents to bring with you the day of the interview to just let the officer know, hey, I submitted everything. I realized I forgot these documents. Here they are. And then the officer will, of course, consider them. But I wouldn't count on the fact that they've already been reviewed by the officer, given that you submitted that addendum late.
All right. Thank you so much, attorney. Let's try to wait for the next question. Let's see here. Right. We just got one from Maria Velasquez of ICE stops me in a bus or a train station. What should I say or not say?
So what we've seen in that situation, I've seen some videos of how ICE officers are behaving. I mean, first of all, if you are undocumented, certain interstate travel, I think would just be not advisable right now, given the consequences of what could happen if you're detained. Because if your last entry was without a visa, you are ineligible for bond, which means they're forcing people to fight out the entire, whether you want to try to do a 42B cancellation of removal if you have children that are here. These kinds of things can take months, even years. And so the risk that you take when you travel across states and you travel in buses or trains is that if you are detained, even if the detention's wrongful, right, and they kind of abuse your constitutional rights in that sense, you could be in a situation until this litigation is cleared up where you're ineligible for a bond. So that would be my initial reaction. Beyond that, my advice is the same in the sense of ask if you're detained or if you're free to go. They might threaten to say, hey, if you don't provide me ID, I'm going to detain you. I wouldn't even get that far into the conversation with the ICE officer. I would just say, am I detained? I want to speak to an attorney. Because both of those phrases have kind of a magic effect. The am I detained forces the ICE officer to explain, yes, I have probable cause to think this because you're on this bus for whatever reason, right? It forces them, it puts the onus on them to explain why they are having that conversation. And then I want to speak to my attorney triggers your Fifth Amendment rights to remain silent. And so if they continue to badger you and push you after you've said those words, that's an important constitutional argument that you can bring up later before an immigration judge. So that would be my advice for that situation.
Thanks so much, attorney. Let's try to wait for a few more questions.
Mm-hmm.
Okay, we have one from Emmanuel. Okay. I think this is the prior question. Can we move on to Emmanuel's question, please? Okay, we got one from Lane. What can I do if my husband is undocumented? I think we're having technical issues with our questions.
Okay.
We
Yeah,
might
but
be getting too many questions right now, attorney. I think that's what's happening.
well, that's no problem. I can definitely stay at least until 12:30.
Really
So
appreciate it.
to that question, do we want to address that one you just asked? The what can I do if my husband is undocumented, or
I
there's a
think
different?
so. We can proceed with that for now.
Okay. So generally, having a spouse that's a U.S. citizen or a green card holder does provide you an opportunity to get a green card. If the person entered without a visa, it's a long process, right? Because you have to first do a spousal petition, get that approved, and then you do an I-601A waiver of their unlawful presence. So prior to 2014, you had to go outside of the country. Let's assume it was a Mexican national, right? You have to go to Ciudad Juarez, which is the consulate general in Mexico. You have to be denied, and then you have to apply for your waiver outside of the United States. And that could take 6 to 8 months in those times. And so a lot of people that were eligible for that benefit, they simply didn't do it because they had kids, they had jobs, they had other responsibilities. So under the Obama administration in 2014, they opened something known as the Provisional Waiver of Unlawful Presence, which is the I-601 subsection A. And that allows you to apply for that waiver inside the United States. So rather than having to spend 6 to 8 months outside of the country, not knowing if your waiver will be approved, now you can wait inside the country and see what the decision will be on that waiver. Now, I should mention that if there are multiple entries to the United States or an immigration detention while attempting to enter the United States, you need to do a background check. You need to find out exactly what the result was of that detention, because it's possible that it carried with it an immigration penalty, and it's possible that it didn't. And there's no way to know until you investigate with certain federal agencies, and it's risk-free. Those investigations don't cause ICE agents to come knocking at your door because you're doing it through your attorney and your representative's office, and they're looking into that information about you. So Whether or not, if you've ever been detained, then I would recommend doing a background search before you get started on that petition. Why? Because right now, if someone's ineligible for their petition, they're getting placed in removal proceedings. They're getting a letter at their home with a court date that they have to show up before an immigration judge. So it does not make sense to start on this process before you've done a full and complete background check. Now, if the person entered with a visa, very simple. You apply for adjustment of status, you're done within 8 months. So I kind of started with the more difficult scenarios, and then I went to the easier one. But in most every case, if you have a U.S. citizen or green card spouse, there's a path forward for you to get your green card as well.
Thank you so much for your patience, attorney. Okay, team, let's try to move on to the next question. I think it was from Emmanuel, if we can go back to that. Thank you so much. So Emmanuel is asking, can ICE enter my apartment without any paper or warrant?
No, legally they cannot. Because an apartment is a private space. So like I mentioned earlier, like if it's a hotel lobby, that's a place that's open to the public. That's a place ICE can be without a warrant. Or if it's like in an apartment complex, but not, like there's a lot of space outside between the buildings, that's a place they can be too, because that's open to the public. But as far as entering the home, the Fourth Amendment strictly requires that agents have a signed judicial warrant, a search warrant, to enter any private residence or private property. So I'm not trying to say that we haven't seen videos of ICE breaking down doors without a warrant. That is a constitutional violation. It subjects them to civil liability. So, but in that situation, obviously don't resist arrest, don't run, but just understand that they have broken the law and that there are civil remedies to address that as well.
Okay, so we have a question from George. Please, if I get detained by ICE, can I still contact my lawyer or family?
This is an excellent question. Thank you, Jorge, for that question. So what I recommend to do is to have a consultation with an immigration attorney that's in your area. I say in your area because they're going to have more intimate knowledge with the procedures as far as the detention centers that are in the area. And what your immigration attorney can do is they can have you sign a form that's known as the G-28. The G-28 is a very common form. Every time I send out a petition or a work permit or any kind of application, I put a G-28 and I put it on top of the underlying form. And it's just stating, I represent this person for this kind of application. When someone's in ICE detention, it's a very useful thing to have a G-28 already signed and already scanned in to an attorney. Because otherwise they have to go through this long process to try to mail you the G-28 and have you sign it. And the ICE officers the guards are not cooperative, and it creates this big headache. It's going to cost more money. It's going to be more stress. So if you have a signed G-28 that's on file with your attorney, they can go in that same afternoon in most cases and have a video conference call with you and discuss your options. So as a preventative measure, and maybe I should have addressed this in my first 30-minute block, if you're concerned about a deportation, you can reach out to an attorney. Now, different attorneys operate different ways. I don't charge for that service because it doesn't cost me any money to have a signed G-28 scanned into my system. Now, of course, I've had people come up and say, hey, can I pay you $5,000 so that if I get detained, you'll represent me? And the answer is no, I can't accept that because that's unethical, because there's a good chance you won't be detained and then you paid me $5,000 to do nothing. So reach out to your attorney, see if they'd be willing to have a G-28 on hold. And that's something, like I mentioned, that I do for clients that are in my area, which is San Jose, California, in the event that they do get detained.
We also have a question from Fatima. Can ICE take me if I'm under DACA protection?
Generally speaking, no, unless you have a criminal conviction. So there are outlier cases that we've seen that I'm aware of, like people that have DACA that are community organizers that maybe have been targeted by this administration. One famous case, there's a community organizer who's in ICE detention, and they're basically not allowing her to renew her DACA. So they're waiting for her DACA status to expire so they can then initiate removal proceedings against her. Now, again, that is an extreme case, and that's someone who was vocal and about her opposition to the administration, and they probably targeted her as a result of that. People with DACA, this is kind of a collateral to that question, but they can still do advanced parole. They can still go out of the country and come back in. I've done it personally with about 12 to 15 clients since the Trump administration. And what I advise them in September of last year was, hey, let's not apply for parole right now because it takes 6 months to get approved. We don't want to be the first guinea pigs in January 2021, or excuse me, 25 or February to see whether or not this administration is going to respect advanced parole. But at this point, we've had 9 months, and essentially, as long as you don't have a criminal record, you can still take advantage of advanced parole. And that means you leave the country. Usually it's because you have a sick relative, although you could also do it for a professional or an educational reason. And then you come back into the country, and that lawful entry makes you eligible to quickly get your green card once your child turns 21 if they're born here, or once you're married to a US citizen. So it's a very powerful tool to have. Also, there's some news that they might start reopening initial DACA requests based on how that's proceeding in the federal courts. The Trump administration has stated that they are open to having initial DACA applications start again. And so just to recap, the requirements for that is that you came in under 16, you came in before June of 2007, and that you're either enrolled in some kind of educational process or you've already gotten your high school diploma. So if you're in that situation and you think you might benefit for DACA, it would be a good idea now to start gathering evidence of your continuous presence. Because of course, the administration did say we reserve the right to cancel this, to change this decision, and who knows, they could do an about face. But based on what they're saying, we could have the opportunity to apply for ICE for initial applicants moving forward, which is something that's very exciting.
Thank you so much, attorney. And that's definitely good news. From Daniel, we have a question. If my family member is taken by ICE, how do I find where they are kept?
So the simple answer is you can go on Google and look up ICE detainee locator, and there's two different ways to search for family members. One is through their A number and their name, but if they don't have an A number because they've never been through any immigration process, there's also a way to do it by their birth date, name, and nationality. So the problem with that is that a lot of times when people get detained, they're not immediately going to pop up in a detention center because they get sent to processing centers first. And once they're at that processing center, it could be 2 or 3 days before they pop up in a detention center. But that's basically the only, if you have an understanding that they've been moved from one facility to another, you have to look up ICE online detainee locator system. It would be your first hit on Google. They have the page can be translated into any other language. And then just keep searching until the name pops up. And then I would reach out and contact an attorney in your area. But it's important to know, if someone entered without a visa, they're not eligible for bond. So that's something, and the reason I mentioned that is because your family member might have a contingency plan in their home country. Because if they don't have a valid 42B deportation defense, which is something I can discuss at a different live stream, or if they don't have a valid asylum case, then they're just going to be detained for 2 years, and ultimately they're going to be sent back to their home countries and potentially deported. So in that situation, given the law as it stands right now, I think taking a voluntary departure is something you should discuss with that family member.
Thank you so much, Attorney Newcomb, for your expert guidance with us today. Your insight to how immigrants can protect themselves and their families from detention and act strategically before a crisis had been invaluable. And to our viewers, thank you for joining us. Remember, preparation is protection. Knowing your rights and having a plan can make all the difference in keeping families safe and united. You can always visit immigrationquestion.com to ask your immigration questions for free and connect directly with a licensed attorney. Many of you may also qualify for a free confidential consultation. And if you'd like to revisit our today's discussion or share it with someone who needs this information, the full replay will be available on Spotify. Search Borderless Talk by immigrationquestion.com. Just join us tomorrow for another vital conversation that could make the real difference in your immigration journey. Once again, thank you, Attorney Newcomb, and thank you for everyone watching. Until next time, stay informed, stay safe, and stay united.
Thank you all as well.